Tonight, Citizen TV can authoritatively report that the government of Kenya, through the Solicitor General Nje Muturi, committed itself to paying nearly 700 million shillings with an additional 145,000 shillings daily penalty charge to Universal SatSpace, a firm that is linked to the Anglo Leasing scandal. A copy of the judgment obtained by Citizen TV indicates that the government lost the case on account of not proving its allegations of corruption in the signing of the contract with the North American firm. Sylvia Chebet will be bringing that story to us shortly, but first I want to start with you, Mutua, because you're a lawyer and you've seen the proceedings. At some point in this whole Anglo Leasing fiasco, the government moved from actually challenging whether or not there was corruption in the case and then decided to enter a mediation process. Why is that?
Well, I think for a start, let me clarify that it is not irregular for parties to go for mediation or for arbitration when a case is ongoing. But for me, it is quite strange that when you have your defense as the fact that the contracts were procured in a corrupt manner, when you have a defense that the contracts were executed or signed by persons who are not authorized by the government to do so, then it beats logic, in my view, for you to opt to go for mediation and again not raise those issues in mediation.
Is this proof to you then that these cases were lost deliberately, or there was some sort of backhand dealing? Well,
let me say that when it is reported that the cases were lost, I don't think the cases were lost, because parties elected, and this time I'm saying the government elected not to pursue the issue of the fact that the contracts were procured in an irregular manner, and decided actually to enter into a consent to pay.
So no case was lost, in fact, we just agreed to pay?
Yeah, it is the government which agreed to pay. There was an agreement which was reached that we are going to pay this much. So it was actually a negotiated agreement that we are going to pay this kind of money.
From the LS case standpoint, is this proof to you that the Attorney General's office is culpable or liable of some sort of criminal or improper dealing in as far as handling Anglo Leasing?
To a very great extent, the Office of the Attorney General needs to explain a lot. Why was it not possible to pursue the defense of these contracts having been procured illegally? Why is it that the issue of international public policy was dropped at the last minute so that they can opt for negotiation? And remember, the Attorney General pursued the world duty-free case at the International Center for Settlement of Investment Disputes in Washington, D.C., where the tribunal made an award in 2006 and said that all those contracts related to world duty-free are not payable because they were procured through an illegality, through corruption. And that award is there. And that is the same defense which the Attorney General initially had taken. Then somewhere midstream, he decided to drop that defense and go for negotiations.
I just want to stick with you for a final question before I open it up to the rest of the panel. LSK had threatened to move to court and prosecute any official who actually signs off on these deals. Now, with this judgment coming to light, what is your course of action?
This judgment is not enforceable. That is the first thing. When you hear people telling you that the judgment is going to be enforced by over-attachment, there is international consensus that any judgment which is procured in an irregular manner through corrupt procedures, or which emanates from a corrupt procedure, then it's not enforceable. So for us, it is not a question of that there's any danger that any item is going to be attached, any item of the government or any property of the government is going to be attached. For us, we are saying that persons need to be held accountable on account of the fact that the government dropped the defenses, which are very strong defenses in our view, and opted to enter into a settlement and say we are going to pay this much. Therefore, it means, in our view, it means that actually this is another plan of some sort to circumvent the fact that the Kibaki administration and also the current government at one point had decided that these contracts are not payable.
Let me welcome our viewers to join our discussion. You can use the hashtag #OpinionCourt. You could tweet us directly at Citizen TV News, at Citizen TV Kenya, at Ann Kiguta, that's Ann with an E, and of course on our Facebook platforms, which is similar. And you could use the SMS line 22422. Sakaja, let me come to you. You've heard the LSK's position. First, that this particular ruling is not enforceable because it was acquired irregularly, and that the government of which the president is a member of your party, went ahead to drop their defenses prematurely. What's your take?
My obvious disadvantage, given the issues that is raised at this point, is that I'm not a lawyer. So I think those are issues that really need to be challenged legally by somebody who understands those, because really for a long time in this country, corruption has been deep-rooted. And it has been a cancer that has been eating at our institutions, it has been eating at our entire fabric as a country. And I think it's unfortunate that this government has had to deal with and to make decisions on a case or a situation that has been brought upon not by itself, but by previous regimes. You realize that this Anglo Leasing contracts started from 1997 to 2004. A number of them had been settled, a number of them were terminated. We also must realize that in the last government between 2008 and 2012, 2 of those contracts were paid worth around 5 billion. I think it's Project Nexus and the naval ship, without going to Parliament. From where I sit and what I understand is that it's a tough decision that must be made. And I think Kenyans must receive the entire set of facts. I understand that this matter went to court. And where it went to court, the government lost the case. And in as much as we must be able to find out if there was professional negligence in respect to the Attorney General from the beginning, from the Attorney General who is now the Senator of Busia, Amos Wako, he must be able to account for it, and the current Attorney General, Githu Mugai, they must be able to tell us whether there was any professional negligence in the pursuit of this case.
What in particular would you do to, if you like, even if it is just whip up members of TNA and then by extension of Jubilee, to push for accountability on the part of these 2 officials?
Before I get there, kindly, and let me just draw the full context as to why we're in a difficult situation.
Okay.
International law has its own sets of standards and regulations and precedents. In such a case where there's judgment against the country, and from our understanding, we've exhausted all avenues of appeal. We are a judgment debtor at this point as a country. They negotiated from, I think, 2.9 billion to 1.4 billion. For one of the projects, which I will not even justify whether it was good or bad. It was just corruption in its thinking. But here we are now. We have a debt to pay, 1.4 billion internationally. We are trying to raise a sovereign bond as a country of 140 billion. Now, this 140 billion, in my understanding, and which is the fact, is at threat, because if we do not pay this amount of money, our credit rating, which right now is at B, it is one of the highest credit ratings in Africa. Kenya is one of the only countries in East Africa that honors its debts. It has never had a write-off. If we do not do that, then we have to actually forfeit getting 140 billion for our...
Fair enough. I believe that this argument has been made before, also by Njem Muturi himself, and we listened to those parliamentary committee proceedings. But I want to go back to the earlier point that you had made.
Yes.
If it is possible that, in fact...
We must get answers. We must, and that's the reason why when you saw the Jubilee members at our parliamentary group meeting, they stormed out because they're saying we must know the truth with respect to, first of all, who are these people you're paying? We cannot pay ghosts as a country. We need to know who are those people, and we are told that there are actually some Kenyans who are involved in these deals. They must be unmasked, and we want to give even an ultimatum of the next 30 days for these people to be listed and to be named, such that once you sort that out, these people's assets must be attached so that we can recover that money, because it's taxpayers' money. But it's a tough decision right now as a government to say whether do we jeopardize what we're getting as a country, 140 billion, our credit standing, which takes years and years to build and to get to, for 1.4 billion. Or do we condone it?
What does Johnson Sakaja believe?
I believe we must get the truth out of it. That's what I believe.
So you're not committal on whether or not these payments should be made?
I think where we are, it's a tough decision, and we must pay so that we can maintain our credit rating and be able to access that. But we must see prosecutions. The DPP, the Director of Public Prosecution, must actually open that file, because it's not a closed case. There is a political culpability from the previous governments, and there is also criminal culpability. We want those people behind bars. People can't be waiting in Kenya to go laughing to the bank. in a few weeks after that amount is paid, they must be surcharged and they must be in jail, really.
Chris Wamalwa.
Yeah, thank you very much, Anne. One thing I want to say is that we should not pay about this issue of Anglo Leasing. The whole saga of Anglo Leasing is a conspiracy between the people who are well known from the executive. So when you read Article 201 of the Constitution, it's very clear, this is the principles of the public finance. There must be openness and accountability. This whole saga of Anglo Leasing, there's no openness. At the moment, you don't know who are these owners, but the executive must be knowing this. I went through the report of 206. But you just
said these people are well known. Who are
Absolutely.
they? Who are
well known.
If
given a chance when I'm in Parliament, where I enjoy some privileges, we have some information I can name them.
Well, the issue, the
issue is this, Anne. When you read this Article 201 of the Constitution, aspect of openness and accountability, it's not there. And the issue of Mheshimiwa Sakaja saying that we've already exhausted all means of appeal. First and foremost, you need to know, Kenyans need to know, that we've not done any appeal as far as this case is concerned. The appeal they're talking about, when this case was submitted, there was some evidence of corruption. This report which came out from the public, from PricewaterhouseCoopers, this was an auditing company. And at first, the ruling was, it was disqualified. But after the government appealed, it was later on accepted. Okay? So that evidence was accepted. But when it was ruled, we've not done an appeal. Again, when you look at the level of defense that was there, why I said it's a conspiracy, the government got weak defense so that we lose the case. And this is why the issue of conspiracy is coming in. Article 226 of the Constitution is very clear. If anyone is going to pay that amount of money, any public officer who pays the money illegally is going to be surcharged. So those government officers who have gone to do the commitment without following the due process of the law, they're going to be surcharged.
I want to take you back to this point of people who are well known, because we've heard this incessantly on numerous issues from the court coalition, people who are well known, but we never see these names tabled on the floor of the House. When are you going to table names, since you clearly know who's behind this? When will we see Chris Wamalwa on the floor of the House saying, Mr. Speaker?
And I think additionally you should go to the CID.
Actually, I think
or perhaps, yes, hand it over to the CID as well.
Who was talking about this issue.
Tell us the people.
One thing I want to say is this. When we went to the floor of the House, the Jubilee government was bringing that motion. But after they sensed the defeat, the court members, even there's some members of the Jubilee, because when you read Article 95 of the Constitution, we know what National Assembly is supposed to do. It is not a house of clearance. It's not a house to rubber stamp illegalities. And the members of Parliament know about this. It's no longer a tyranny of numbers. Members of Parliament are not just following political parties for the sake of it. Things have totally changed, and I want to congratulate the honorable members for coming out clearly. And what Mheshimiwa is saying that we should pay, we cannot pay. We represent people.
I appreciate the point you're making, sir, but back to my point. If you still strongly believe that you do, in fact, know these names, then why not hand them over to the police for investigation?
I didn't say I know the names.
But you said they're well known.
What I said is these are well known.
By whom?
We have people who know these names.
They are in the report.
Oh, but not they're actually in the reports. Yeah, these things are in the reports.
Please,
so
please allow me.
In fact, if I told that motion was not withdrawn from the floor of the House, I'm sure the names of the victims will have mentioned. And I want to challenge Mheshimiwa here. You can't come out and say that you're going to pay. When you talk about the sovereign bond is talking about, there are many factors that we look at in terms of the costing of this sovereign bond. First, they must look at the prevailing conditionalities. For example, the case of ICC, which you are facing, the war in Southern Sudan, which is going on, the issue of Somalian pirates. All these conditionalities put in place, they are going to make the first sovereign bond not to be cheap, the way people are trying to portray.
Look, I must bring in Professor because we're about to go to a break, but I want you to first speak, Prof. You've listened to the arguments. What do you think?
I think let's let this argument gain some intellectual territory and honesty. I think when you look at the Anglo Leasing, the best way to look at it is to begin with the events of April and May 2004. First, you go to the story given and the presentation made by former MP Maoka Maore in Parliament about Anglo Leasing dossier. Then you look at the activities of John Githongo, probably the finest Kenyan we have ever had for a long time. And then what he did while he was serving as secretary, as permanent secretary in the office of the president, in charge of these things about corruption.
Yeah.
And if you look at all these two guys, there is a very big story there. And then even the subsequent evidence that was gathered by Githongo, you are asking the two MPs to name the people. If you read the publication which came from London, It's Our Time to Eat by Michelle Arong, who is a distinguished journalist. The names of the people who are involved in Anglo Leasing, right from the frigate construction, in the naval ship construction in Spain are mentioned. The people who are caught on tape and even their voices were heard on BBC and relate on television are known. The people who went to Parliament and announced that they had suspended payment of Anglo Leasing are known, and as a result of that, the secretary to the cabinet then even called Githongo and told Githongo that, you see, money has been returned. The finance minister followed and said that 91 million shillings had been returned by unknown people. Now, the whole story, when you look at that, boils to one thing. Anglo Leasing is a breach. It is a breach which consummated the relationship between Moi and the Kibaki administration. It is the one that dissolved differences between the two regimes and made them one mass government that ran from 1978 to 2010, to 2012.
Is it a breach now?
And now, what I'm telling my friend Sakaja is that don't join this government to continue with the vice. Please keep off Anglo Leasing and let the people who are known. If you read Michelle Arong, and that report has, by the way, not been challenged by anybody. Even those who are caught on tape, they went back to government. So really, what you need to advise your government, because it is a young government and it is probably not part of this, is let them not try to protect the people who stole our money. And it was bad public relations for the secretary to the treasury to even post an advertisement where he was talking about payments of only 1.4 billion, even if it was only 5 cents. We can't pay people we don't know. Somebody must go to court.
Let's have Sakaja respond, and then I'll come to you, Mutwa.
I agree with you. In terms, morally, it feels very wrong. It's actually a wrong thing. We should not, because it looks like we're condoning corruption.
Yes.
The reason why I'm saying our government is very open and transparent, this government, this Jubilee government, is that in the last government, and I'm very excited to see Mheshimiwa Wamalo talking the high priest of integrity, because even his party leader was a part of that government. 2/3 of the leadership was Raila Odinga, Kalonzo Musyoka, Wetangula. They were there. The cabinet approved payments of up to 5 billion. They paid without telling anyone. They paid it. This government has said, look, this is a dilemma that this government is facing. Why don't we bring it to Parliament so that the representatives of people discuss it openly, because it's an issue we must face right now as it is. And I'm glad that Mutwa is here and will tell us, actually, if the avenues to appeal, I'll be very glad, because I don't want us to pay this money. But right now, every day, interest is accruing of 260,000 shillings. Kenyans must make a decision on this thing, and we must slay the ghost of Anglo Leasing.
What do you say to those, Sakaja, who say that in itself is just an attempt to sanitize it or to have it endorsed on a broad scale, so that we all as Kenyans take responsibility for the actions of certain individuals who should be behind bars?
No, it is not an attempt to sanitize anything. Our constitution talks about the principles and values of governance. If you look at Article 10, public participation and inclusivity is important. How do you make the public know about it? I mean, if government wanted to pay it without involving anybody, they'd have done it, like the previous government.
But let me ask you something.
But
why don't you do this? Yeah. Why must we do this? Recall Githongo. Yes, recall Githongo. And
I think it's something that needs to be done.
And two, call back the secretary to the former secretary to the public service. We need to call the former AG and ask the former AG, and then ask about Maoka Maore. These people, I agree. These people have a lot of information.
I agree, but do tell me. You're finishing my minutes.
All right, let me bring in.
Let me say this.
Please go ahead.
I think we are losing focus on what we need to focus on now. In my view, we have a situation where we have two decisions from a court in London and a court in Switzerland. And as you said very correctly, we should be focusing on the attempt now to sanitize what was done wrongly, and what the government has said is not going to comply with, both the Kibaki administration and the current government, by way of a court system where we are told that is a decision from court which binds us to pay, irrespective of the circumstances.
And therefore it is legal.
And therefore now the payment is...
That is what we're being told.
That is what we should focus this debate on. And I think Kenyans should now be looking at what transpired between the time the defenses were filed and when this apparent judgment
No,
has
you-
come out.
no, and again-
Let him finish his point.
You're not getting the
let
point.
Let
me
him
say,
finish his point.
Mheshimiwa was saying that we had a weak defense. No, I don't think we had a weak defense. Our defense was very strong. The issue, as I said earlier, is that our defense was not considered in the decision because we as a government dropped our defenses and went for arbitration
opted for
argument.
arbitration
That is what I'm
instead.
saying.
First to move forward on that
But
point.
Sakaja, let's
First to
listen.
move forward on
What
that.
is my time now?
What I want, and I'm glad Mutua is here.
You're not in parliament. It's everybody's
That's the point,
time, but
yeah.
I'll come to you. I'll come to you.
We're with Mutua here. I think Kenyans understand the situation we're in, and you're also saying you understand it. Even as interest is accruing of 260,000 shillings daily, I'd like Mr. Mutua to tell us what legal options we have, because what we've been told, and if it's misinformation, I'd like to hear it.
If
What
she
we've been
allows
told
me, I can tell you
is
that.
that we have no more avenues of appeal, and that's the situation we know. I'd like probably for us to hear from him
Yes.
what legal recourse we have, because it is not money we want to pay.
We'll
We're
do
not in
that.
love
We'll
with
do
Anglo
that.
Leasing.
We'll do that. We'll give you that opportunity after the break. Let me take in Wamalwa's views right
Thank you
now.
very much. You know, and I don't like scrambling for talking.
All right.
So when I'm given my time, I use it effectively so that I don't
and
eat
now
it.
you
You're
have
wasting
it.
it.
And now you have
Now
it.
the
Please
issue
go
is,
ahead.
what I want to say is, in 2006, when you look at the PAC report, we've seen it clearly what the recommendations were. One of the recommendations was that we must have an executive approval. At the moment, we've not had any executive approval, because executive approval means we must get the cabinet. And you look at Article 253, the Secretary of the Cabinet is supposed to be Kimemia. We've not seen any report or any written memo that he has given. Another issue, and what I want to say is this is the highest time we need to know who are these people behind Anglo Leasing. Article 35 of the Constitution is very clear in terms of access to information. Kenyans want to know, and the government has the capacity. We have seen the Auditor General's report, what he recommended. What is the government doing about this?
Now with a final question where I'm hoping for your final opinions generally on the topic, and it's the same one to all of you.
Yes.
What next, Prof?
What is next is that let's be honest, and the government, this government knows who was involved in Anglo Leasing. So what the public will expect is for these guys to undergo serious prosecution and taken to court. They belong to jail. They don't belong to the public. And once it does that, I think it is easy to persuade the public to say, let us pay. But for now, we can't pay because from the start, people in government pretended there was Anglo Leasing, but you know the dossier we have is even Anglo Leasing itself is not a legal entity in Britain. So we started by dealing with an entity that didn't exist. So then the series of other companies posing as Anglo Leasing and getting involved in things like the Mahindra saga, a lot of money has gotten lost more than what we are even thinking. So the government we must see prosecution, evidence given, and people in court, taken in court and jailed. Then you can get back to the public and ask, what do we do with our reputation? That is my point.
To me, and I think the big thing is corruption. We've talked so much about the wage bill. I read about the Auditor General's report. There's a lot of wastage in this country. 300 billion goes through corruption, and Anglo Leasing is one of them. So this is the time the government should come out. We should be able to know who are these people behind Anglo Leasing. We are not going to pay, and we can't pay, will not pay. And these are the same words that His Excellency the President, when he was the one in charge of Treasury, he said, you're not going to pay. And I know at the moment His Excellency the President still believes in that. But the people surrounding him, or whoever they are, as I said, it's a conspiracy, who want to get this money in the form of pretense that we've already exhausted all rooms of appeal. We still have rooms of appeal. We don't want people to come, like Mheshimiwa Sakaja, to come and cheat the Kenyans. We all know, and Wakili has also mentioned, there's a court of appeal that we have to appeal. And we need to know which kind of the legal defense are we going to put in place, because in form of conspiracy you can as well get weak defense, so that when you go there you go and lose the case pretending you've lost, and when you go back the door you find that there's that conspiracy which is there and you're getting the money back. When you look at the report of Parliament is a house of records, and there's a report in 2006 by Parliamentary Accounts Committee. It has given its recommendations. This has not been done. We are not going to get out of precedence. We go as per the traditions of Parliament. So the issue of coming up again and saying payment, we are not going to accept that. And I congratulate the honorable members of Parliament, both from the Jubilee and both from CORD, for the stand they took. And I want to assure them, we'll not pay, and we can't pay, we'll never.
And I want to, Mutua, as you answer your question, please also indicate what exactly LSK will be doing in that regard and what the legal options are for Kenya.
Yes, thank you very much. The door is not shut for the government of Kenya to challenge those decisions from London and Switzerland on two accounts. One, as he says, you can still ask for leave in the higher court for you to challenge that decision if leave was denied at the court where the trial was taking place, as is the case in London. Secondly, when you bring the question of corruption, when you bring the procurement of contracts by way of corrupt means, you can still reopen the case afresh. You only need to indicate that because of these reasons, we need to reopen this case. The other avenue is this. These are foreign judgments. These are not judgments from international fora. These are foreign judgments which are from courts, domestic courts. And therefore...
And not from international
Yes,
courts.
not from international, from domestic courts. Therefore, and this is what LSK intends to do if the government does not take the step, the government has an option to come to the domestic court here and say, look, when it comes to enforcement of this decision, it cannot be enforced because, one, it may have been procured in an irregular manner or in a manner which is against public policy. And therefore, the courts can make a declaration that in view of that, this decision cannot be enforced.
All right, Sakaja.
Somebody gave me an analogy when I was coming, and I'd like to ask even Professor, if your son steals your credit card and spends it in a shopping spree, and you get a bill, will you say that it was procured illegally, or you first sort it out, then you come domestically and sort out the issues? And
it's my son, and I know my son by name.
Or whoever, if someone steals it, or if your son
Not Anglo Leasing.
the goats to go to the neighbor and they eat everything, you must first sort it out. I think from what we understand, and I think even from the story we've seen by Sylvia Chebet, the avenues of appeal are exhausted. I'll be very happy to learn that there are actually certain avenues that Professor, that Mutua and Chris know about. Maybe they have different courts. If the other avenues, that is the best thing, because Anglo Leasing was not started by this government. It's been there before. It is something that we all hate. The government is not happy about dealing with this issue, but a decision must be made. And this government has shown exemplary openness and transparency by coming to Kenyans and saying, look, Kenyans, we have a bill, we have this issue. How do we sort it out? Because there is also a cost of not complying with that international award. So I think we must juggle the legal issue. And I'd like to ask my friend and even those in court coalition to stop pretending that they can actually dance on this issue, because they actually have been proven to be more corrupt in many issues, especially a lot of the parties in court. So let them not use this thing for politics. It's a Kenyan issue that we
And I
must
hope
deal
that
with.
you're not doing the same on this platform. It is at that point.
But
I beg your pardon.
as
Gentlemen,
as a
please.
country,
Gentlemen, please.
allow me to finish.
Gentlemen, please, we really, truly must wind up. You made an
Allow me to
assertion.
finish. I've not
Sakaja made
finished.
an assertion.
I've not finished.
Hold on. You made an assertion about the fact that this government has been exceedingly transparent on this question.
Yes.
Let's find out if the public does, in fact, agree with that, because they've been sending in their feedback on 22422. You do not leave us your name, but you say, we are told the Anglo Leasing was a ghost company. How did ghosts go to court, and who will receive the payment on their behalf? In Kenya, leaders are the problem. I don't agree with Chris Wamalwa. He will not suffer. Dawa ya deni ni kulipa. Again, we do not have the name of the sender for that. So a lot of feedback generally going around the fact that at the end of the day, Kenyans do want actual names. Sakaja, I'll let you make a final point, and Chris Wamalwa as well, as we continue with our audience feedback.
Okay, let me say this finally. Kenyans want answers. We as parliamentarians want answers. We want the names unmasked. We want the real culprits brought to book. We want heads to roll. We want to make sure that the DPP actually, and he must open up that issue, actually prosecutes, especially the Kenyans who are involved in this matter. But as we go on, we also need to put a lid on it, because Anglo Leasing wins if ultimately we will still have to pay a higher amount. If it's going to cost us now 20 billion as opposed to 1 billion, we need to put a cap on it, and also be able to honor our international obligations, get our sovereign bond of 140 billion that will develop this country, and recover the 1.4 billion, whatever it is, from these culprits who actually participated in Anglo Leasing. So I think this government is open. We're committed to ensuring that corruption is sealed. We do not want to be part of it, but Anglo Leasing must not haunt us forever as a country. It must stop at a certain point. And it's difficult decisions that must be made. This government is ready to make those difficult decisions, which are for the ultimate good of the Kenyan people.
Mine is to caution the Solicitor General, my friend, not to commit anything him to go read Article 226 of the Constitution, which talks about financial responsibility. Any public officer who is going to pay an illegality is going to be surcharged, whether he's in office or when he's going to be out of the office. And the truth is, the stand remains, we won't pay and we can't pay. Thank you.
All right, let's take your feedback now. Thank you so very much for sending it in to us on @Citizen TV Kenya, @Citizen TV News. You're using the hashtag Opinion Court, and thank you for making us trend this evening. Let's get straight to it. All right, here we go. This is about Labor Day. Isn't about pay rise only. It's more about celebrating input of the common worker to the economy. Thank you for that. There was nothing today about workers today. It was a battle between trade unions. Hashtag Opinion Court. The government has no business funding corruption. Now we're on Anglo Leasing. The billions will hurt our economy. Why pay for Anglo Leasing instead of prosecuting those involved? Well, Ann Kiguta, I think if it's the responsibility of the Kenyan government, then it has to pay. This is our last one. The truth should be told. The government, through the Attorney General, should come clean on this Anglo Leasing issue. And it's certainly the clarity that unanimously all Kenyans have sought for. We will continue to pursue this story for you, even as we hope to get more leads into the various legal proceedings that went on outside the country regarding Anglo Leasing. Thank you so very much for watching Opinion Court today and Citizen Live at 9. Thank you for your feedback. Enjoy the rest of your week. Tomorrow night, Lilian Muli Kanene will be with us on Citizen Weekend. You do not want to miss that show. But for us, it's good night. Thanks to my panel, and God bless you.